As you guys know, last week, Blake Lively has filed a motion to dismiss Justin Baldoni's countersuit. Now, a lot of people were confused because they felt she started this. She filed the CRD complaint here in California. That's where I am. Even though she currently lives in New York and the alleged crimes that were committed were in New Jersey, where the movie was filmed, It Ends With Us. Justin Baldoni lives in California. So she had the choice whether to file here in California or in New York, New Jersey. She chose California, and the question is why? The reason why she ended up filing the CRD complaint in California was based on a few different reasons. And the reason why she's filing this motion to dismiss is really based on California Civil Code 47.1. So what exactly is that? It's considered the Me Too rule by Gavin Newsom. It's kind of like a newer penal code. We'll talk about that just very briefly because I think it's really important to just kind of get out the facts and why she decided to go through California for this jurisdiction and why at first it felt like a big argument, but why I think the more we're thinking about it, I think it's going to be okay. And I think Judge Lyman is he's going to deny this motion to dismiss. And I think we're going to continue to see this this trial play out in front of a jury. So Blake was smart. She had good attorneys who told her, if you're going to go down this path, you're going to want to file in California. A California jurisdiction is going to protect you better. They have various privileges, and especially the California Civil Code section 47.1. Now, I know that sounds a little confusing, but let me try to explain it to you in a very easy way. And by the way, I'm going to tag my friend Zach Peter. He's No Filter with Zach Peter. I'm going to tag him. He is a genius when it comes to all these things. He's been breaking it down really well here on the internet, and we talk on the phone all the time about it. So go and follow him as well for the case updates. But California Civil Code section 47.1, in a really simple way, is a law that protects people from being sued for defamation, basically false statements that harm someone's reputation, when they're making statements in certain situations. The main idea is that certain types of communication, especially in the context of legal or official matters, are considered privilege, meaning you cannot get sued for defamation just for making a statement in those situations, even if the statement is false. For example, if someone makes a false statement during a court case or while filing a complaint with a government agency, that person cannot be sued for defamation as long as the statement was made in good faith and in the proper context. The law encourages people to speak freely and in legal matters without the fear of being sued for defamation. And this specifically works in this case. Like if you're a victim, for example, if you're a victim of some sort of DV or SH or SA or anything like that. And that's why it's considered like this Me Too ruling. It's fairly new. And Blake knew this, and Blake's attorneys knew this, and that's why she decided to file in California. Now, this is Judge Lyman. I found this picture online. He looks like a nice guy, actually. So Judge Lyman has a big job here. He has to decide whether or not he's going to deny her motion to dismiss or accept her motion to dismiss. I believe he's going to deny it, but I'm not a lawyer, but I'm just going by what other smart people are saying. And the reason for that is because in order to deny her motion to dismiss, he would have to first accept if whether or not her case is actually true, meaning is it done with malice or is it true sexual harassment? And Harvey Levin actually had some really good points. My friend Zach had told me that Harvey Levin said this. He basically said, number one, it comes down to two things. Number one, the events happened in New Jersey or New York, so it's a jurisdiction issue. And number two, was she actually harassed? The privileges protect victims of harassment, not false statements, which is a matter for a jury to decide, not a judge. So Judge Lyman has to say, listen, I'm not the one that's going to decide whether or not she was harassed. Your jury of 12 peers, they have to decide. So if I decide, it's putting the cart before the horse. So we got to go to a jury first. They have to decide, was she actually harassed before I can decide if this motion is dismissed. So deny on the motion to dismiss. Let's go to trial. Let's get it in front of the jury and let's get a decision there. So crossing my fingers, her motion to dismiss gets denied, and then we continue on to the trial in the saga that never ends with us.